Hello, everyone, and welcome to today's Mondac webinar in association with McCarthy Tétrault LLP. Experts from McCarthy Tétrault, recently recognised by Chambers as the Canadian Employment and Labour Law Firm of the Year, will cover current and emerging Canadian developments, trends and news in labour, employment and immigration law, as well as human resources practices. My name is Dan Sampaio, and I am joined by a brilliant panel to take us through today's discussion. Our host for today's session is Tim Lawson. Tim is a partner in Toronto and the National Practice Group Leader of McCarthy Tétrault's Labour and Employment Group. Tim acts for many well-known Canadian and international companies operating in most sectors of the economy, including energy, financial, transportation, retail and construction. He has considerable expertise in the federal sector, where companies carry on business across provincial and national boundaries under federal regulation. Before we begin today's webinar, a quick housekeeping item. You can submit questions to the panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible throughout. It's now my pleasure to hand you over to Tim to begin. Thank you.
Thank you, Dan. It's always nice to be referred to as experts and brilliant. So I really appreciate your introduction there. I'm gonna hold you to that next time as well. Look, we really enjoy our association with Mondac. We've done now multiple sessions with Mondac, providing legal updates, years in review, case law updates. This session we're calling all things Canadian employment law, which in an hour is basically impossible to cover that as a topic. But we do have a an hour-long session today, filled with what we think are very topical case law updates, statutory updates across the country, all of which I think should be useful for those participating today. And thank you for those returning to this webinar series. And it's nice to meet you who are new, and hopefully you return to our sessions, which we're going to continue with Mondac next year as well, along the same themes. But speaking of expert and brilliant, I want to introduce you to the incredible panel we have today from our National Labour and Employment and Immigration Group. We have Justin Turk, who's a partner in our Calgary office. We have Carolyn Arnier-Bernier, a partner in our Montreal office. We have Sarah Adler, who's a counsel from our Toronto office, and she's in our immigration division. Marco Fimiani, who's an associate in our Toronto office. Sarah Hickey, an associate in our Vancouver office. And Kim Lennon, who's a very new hire for us. So we're very happy to have her in our group from Toronto as well. And if you forget where they're from, you can just look at our backgrounds. And if you've ever been to these cities, you might recognize that each background kind of reflects where they come from, hopefully. Although Justin's is a little bit more difficult to make out. I'm not sure I see Calgary in that background, but I do see buildings, which I'm presuming are from Calgary. Anyway, enough about that, enough about me. I want to just turn to the next slide and give you a bit of a roadmap as to where we're going today with our session. So there's our introduction page, of course. Let's go to the next one, Aaron, if you don't mind. Okay, here's our agenda today. So as I said, legislative updates. We're going to cover 3 provinces, the biggest provinces in Canada. Ontario, British Columbia, and Quebec make up, I think, about 75% of the population in any event. Want to talk about something in the second agenda, which is expression and union interference in Quebec. Very interesting developments there, which Caroline will speak to us about. Immigration law updates. You can't open up a paper in Canada without immigration being on the front page. And so we have Sarah Adler here, and she's going to sort of tell us about recent developments as of 10 minutes ago that have been introduced or discussed by the federal government, which she was busily working on about 2 or 3 minutes ago. Want to talk about some interesting cases on family law, discrimination, workplace harassment. Always a topic, probably becoming more prevalent as we have reporting systems in place with employers. We have occupational health and safety statutes. We have human rights codes. Very topical issue, and we deal with matters like that all the time. Finally, we have a section left open for questions, although I do know that we can take questions during the course of this presentation. There are a lot of people who are on this webinar in the audience, so we might not get to all your questions, but you can put them up on the app, and I'll try and get to some of them if I can, either intersperse through the presentation or at the end. So without further ado, I am going to turn this over to Marco Femiamini from Toronto.
Great. Thanks, Tim, and good morning, everyone. If we can just move on to the next slide, I can speak to some legislative updates for Ontario. So in Ontario, the Digital Platform Workers' Rights Act 2022 will come into force on July 1st, 2025. This is a legislation that will apply to a worker who performs digital platform work in Ontario. And the legislation will define, or does define, digital platform work as basically the provision of rideshare, delivery, courier, or other prescribed services by workers who are offered work assignments by what the Act defines as an operator on a digital platform. And then the Act goes on to kind of outline operators of the digital platforms, or basically those who facilitate the performance of digital platform work by workers in Ontario. Now, this Act is pretty important in that it sets out minimum standards that must be complied with once it comes into force next year on July 1st, 2025. This includes obligations like record keeping, providing information regarding the legislation to new workers within 24 hours of being given access to work on the operator's platform, a recurring pay period, minimum wage, some measure of job security standards, and a few other standards as well that will apply. And what's interesting about the Act is that other points of interest will include that all operators and worker disputes must be resolved in Ontario. And the Act will also set up a no reprisal regime, whereby operators are then prohibited from engaging in reprisal against a worker and will not be able to intimidate or penalize or attempt or threaten to intimidate for a worker for inquiring or enforcing their rights under the Act. The government will also engage compliance officers who will be appointed to enforce the Act, and these compliance officers will also have investigation and inspection powers. And what I'd also say is that you'll hear from my colleague Sarah speak about similar and related legislation in BC, but other Canadian jurisdictions are also making changes or contemplating changes to address gig workers generally in their respective provinces. And even the federal government, after some consultations in 2023, on June 21st of this year, welcomed royal assent of changes to the Canada Labour Code intended to address some of the discussions that came out of the consultations related to gig workers. And one such change at the Canada Labour Code, so for the federal workers, is that there's now a presumption of employee status to the CLC, whereby all federal workers, including gig workers, will now be considered employees unless proven otherwise when their classification is contested. And the basis for this change from the federal government was to account for concerns that were raised through consultations regarding the employment status or worker classification of individuals operating in the gig economy, so to speak. And so with that, I'll just turn it over to the next slide.
Great. Thank you, Marco. Yeah, that's interesting legislation. You know, you can go a bunch of different ways with that legislation. As you said, you can treat these people as these gig workers who are like freelancers, right? Essentially, operating on apps. You can treat them as independent contractors. You can treat them as employees. You know, the governments do different things with these groups, and you can see in the U.S. Multiple states treating these people in multiple different ways. So it's interesting to see this legislation coming out of Ontario, which is, you know, dealing with the issue, I suppose, but also not creating a deemed employment relationship, which I think for employers is extraordinarily important. British Columbia, Sarah Hickey, let's talk about some legislative updates there.
Thanks, Tim. And just following what Marco said, I'll start with the second bullet point there. So as Marco alluded to, there's also some gig worker legislation that's just come out in British Columbia as well. So just this past month, on September 3rd, 2024, new amendments to the Employment Standards Regulation and a new regulation under the Workers' Compensation Act called the Online Platform Workers Regulation came into effect. These amendments follow changes to the BC Employment Standards Act and Workers' Compensation Act that provide that app-based ride-hailing and delivery workers, referred to sometimes as gig workers, are considered employees specifically for the purposes of employment standards. And so the new regulations will apply to online platform workers and platform operators. So online platform workers are workers who pick up and deliver online orders through an online delivery platform or who transport passengers hailed through an online ride-hailing platform. Platform operators are individuals and companies who operate online delivery or ride-hailing services that connect online platform workers with customers. So prior to now, as Tim mentioned, a lot of gig workers were considered independent contractors. And so these changes are under both workers' compensation and employment standards. So they will now be considered workers as defined for the purposes of the Workers' Compensation Act. And so what that means is that workers' comp coverage from WorkSafe BC will be extended to these workers. Employers will need to register for coverage, pay premiums, adhere to reporting requirements, and investigate injuries. And so with respect to employment standards as well, new employment standards will apply to online platform workers, including a minimum wage for engaged time. So that's $20.88 per hour. There will be a new distance allowance, new requirements relating to termination and suspension of these workers, and employers will also be required to provide certain information about tasks that the online platform worker is assigned to. It's important to note as well that at this point, not all employment standards will apply to these workers, only some. So at this time, online platform workers would not be entitled to vacation, statutory holiday pay, overtime, or many hours of work requirements would not apply. So some, but not all, employment standards will apply to these workers. And then just going to my second quick update in BC, there have been some updates with respect to pay transparency in BC. So in 2023, in May, the BC Pay Transparency Act became law in BC. As a result of this new legislation, there were a few different changes. One was that all job postings by provincially regulated employers in BC are required to contain pay information, either a salary or a range. And because this legislation was so new, we didn't have a lot of information about what exactly the government would be requiring with this. But thankfully, in 2024, BC has published some new guidance about what is expected for job postings. And so the government has specified that for ranges of expected salary, the range must be indicated, but the size of the range in the job posting will be at the employer's discretion. However, it must be the employer's reasonable expectation. So whatever the reasonable expectation for the salary would be must be included. The salary does not need to include bonus, overtime, commission, tips, or benefits, and it does not apply to general help wanted posters. As well, the BC government has also published a new tool online to help employers who meet the definition of a reporting employer to publish their pay transparency report. So this is a big development in the pay transparency sphere in BC, that certain employers will be required to produce a pay transparency report each year. So for this year, November 1st, 2024, all employers with 1,000 or more employees in BC are required to publish a pay transparency report. But for 2025, it will be all employers with 300 employees or more. And in 2026, it will be all employers with 50 employees in BC or more. So this new tool will help employers create their online transparency report. And so if it doesn't apply to your business right now, it may apply, this reporting requirement may apply in the future. So it's worth taking a look at. And I'll turn over to the next slide, please.
Thanks, Sarah. Just a couple of just points on that. What's interesting about the BC gig legislation is it doesn't do what Ontario did, which was it doesn't keep them as independent contractors. It deems them to be employees, but then they exclude the gig workers from certain protections under the Employment Standards Act that normal employees get. in any event. But what I was curious about is the minimum wage. $20, which I believe is higher than the regular minimum wage for regular employees in BC. No?
That's correct. I should clarify that this new wage only applies to engaged time. So it's only from the point, and thanks for asking that, Tim. It's only the point that the online platform worker accepts the task and then is, performing it. So I think that's why it's a bit higher, because the worker may be driving around not performing any tasks, and the minimum wage wouldn't apply to that time. So it's just the minimum wage for online platform workers would only apply to the engaged time period.
Yeah, they're sort of building in a premium, I suppose, for the waiting around, right? That employees who would be on call would otherwise be paid for.
Yes.
So okay, that's interesting. And just the other piece is on the pay transparency. Is it clear yet from the legislation whether the government will publicize those reports on employer wages, like the 1,000 or more employees, and then it decreases over time?
Like for each employer?
Yeah.
Or
yeah.
So there are all the employers are required to post their pay transparency reports publicly. I believe that they are going to create a general report based on the information that is published, but each employer will have to publish their own report on their own website, or make it available for employees. So the employees will be receiving the information specifically about their workplace and employer. So it will be publicly available.
Yeah, that's a big change. It's a huge change, right, for employers generally in BC who aren't required to tell anybody what their pay scales are. So remarkable developments in that area of pay transparency in BC. Well, let's move to Quebec, and Caroline, let's talk about some legislative updates there.
Sure, thanks, Tim. So we wanted to discuss two recent, one older one and one very, very recent update. The first one is an act to prevent and combat psychological harassment and sexual violence in the workplace. So last March, so in 2024, the government passed this bill, which is also known as Bill 42. And as a result, a number of employment laws have been revised with the clear aim at preventing and fighting harassment in all of its forms. These modifications bring Quebec much closer to the harassment prevention regimes that existed in Ontario and BC, where those provincial legislation were much more prescriptive. And so there's a number of different changes, but the one that interests us probably the most right now is modifications to the minimum content that must be included in policies, in harassment prevention policies. And those modifications came into force on September 27th, so about a month ago. And so from now on, all harassment policies in Quebec need to contain the methods to identify, control, and eliminate harassment risks, information and training programs on the prevention of psychological harassment that are offered to employees, persons designated by the employer to handle a complaint or report, a clear process for handling complaints, the measures to be put in place by the employer to ensure the confidentiality of a complaint, including records retention periods of at least 2 years, and all the measures that are put in place to protect employees from reprisals for reporting or participating in an investigation related to harassment. So it's important that if employers haven't done so yet, that they review their harassment policies to ensure compliance with the new legislation. The second one is pretty fresh off the press too. It's an act mainly to reduce the administrative burden of physicians. And so on October 9th, 2024, the National Assembly passed Bill 68. And the goal of the act is, as its title suggests, to reduce the administrative burden of physicians. So its primary objectives are not to regulate employer and employee relationships, but it certainly has an impact on them in the way that the bill was drafted and assented. So under current legislation, an employer may be entitled to ask employees to provide medical documentation when they miss work owing to sickness or other medical reasons. The Act Respecting Labor Standards specifies that if it is warranted by the duration of the absence or its repetitive nature, for instance, the employer may request that the employee furnish a document attesting to those reasons, and that would include medical notes. However, through Bill 68, as of January 1st, 2025, the employer will not be able to request medical documentation for the first 3 periods of absences not exceeding 3 consecutive days taken per period of 12 months. This means that for the first 3 periods of sickness, so the first 3 times that an employee leaves on sickness over a period of 12 months, the employer will not be able to request a medical certificate to justify the absence for the first 3 days of these. So if you calculate them, it's up to 9 days in a year, non-consecutive, but 9 days where the employees could presumably be sick and not have to provide any medical documentation. So the employer will be able to require medical documentation as of the 4th day of absence of the first 3 absences, or on the first day of absence of the 4th absence over a period of 12 months. And the bill also provides penalties for employers who contravene the rules. And the bill also imposes limits on the types of services that insurer or benefit plan administrators can require from an insured participant or a beneficiary to receive payment for certain benefits. And it prohibits the imposition of a frequency of visits with healthcare practitioners in order to continue to be eligible for some types of benefits. These provisions are relevant to employers insofar as employers are self-insured, because they would most likely be considered to be benefit plan administrators in that context. So this will certainly require employers to review their employment policies and practices related to justifications to provide in case of absences, and also collective agreements which may, and if they do, likely give rights to the employer that may actually contravene the upcoming provisions. So that's it for me for now.
Great, thanks, Carolyn. It's interesting on the last point around the burden of physicians. I was just reading an article in the paper just the other day, and our federal government is requiring its federal public servants to come back to work more regularly post-COVID. And the physicians in Ottawa, and there's tens and thousands of federal public servants, are complaining about the burden that they have to write medical notes for those people that want accommodations, who don't want to return to work for certain reasons, whether it's family status reasons or from medical reasons or what have you. So it'll be interesting to see whether the federal government does introduce something along these lines as Quebec has done, which I think is a unique statutory clause compared to the rest of the provinces.
No, for sure.
Okay, so let's move on to an immigration update with Sarah Adler.
Okay, thanks, Tim. So we have a lot of different topics to cover today. So it'll be a little bit of a laundry list, introducing topics and not going into a huge amount of detail, but just a reminder that I'm always available to anybody who's got any questions. So feel free to reach out if you need more detail on any of these topics.
Okay. Can I just interrupt? I apologize. It may be that we're going to move to the freedom of expression section in Quebec. It looks like that's what's up next on our slide. Would that be you, Carolyn? Or
Yes, that would be me, but now we're at the immigration law update.
So, okay, sorry, my apologies. Let's get right into immigration. There's a lot to cover there, Sarah. Sorry.
Okay. So the breaking news this morning is that they bumped up the announcement on the immigration levels for the next year. And the announcement was this morning with the briefing with IRCC being done at 12 o'clock today. They have decreased the overall number of annual permanent residence applications down by 100,000, over 100,000 applicants for the year. And they have also instituted a cap on students, which we already knew was coming, was already in place, as well as foreign workers, which is brand new for Canada. The cap on foreign workers is split into both the temporary foreign worker program with Employment and Social Development Canada and the International Mobility Program, which is housed more with IRCC. The total number that we're looking at between those two different topics for 2025 is 367,750, and then decreasing to only 210,700 in 2026. So they're very aggressively trying to decrease the number of foreign workers within the country. This is going to have a huge effect on how these programs function and how we work through them going forward. But at this point, because we haven't yet had the IRCC briefing, that's yet to be released. And so keep your eyes out for further updates going forward. This will kind of put in position the other announcements that we'll be talking about today. So if we can move to the next slide. So many of these changes have happened from about July this year down to, again, about 10 minutes ago. There has been a change to postgraduate work permits. So previously, if you had a postgraduate degree in Canada for at least a year, you could get a postgraduate work permit. They are now limiting those. So the duration of the work permits will still be related to the duration of your program. However, if you have a university degree, you will have to also provide a language test showing that you meet a language requirement of CLB 7 in order to get a postgraduate work permit. If you have a 1-year degree or diploma from a university, again, it's the same. You would get the 1-year work permit, and you would have to submit a language examination for CLB, showing that you meet the CLB 7 requirements. If you have a college degree, the language requirements are reduced to CLB 5. However, you also need to show that you will be employed or you're seeking employment in your area in which you studied. And it will be limited based on your area of study. So occupations that are seen as in demand. So the key ones right now that are that they'll be offering postgraduate work permits for will be in STEM occupations and healthcare. There are a couple of others, but those are kind of the key areas right now. The program will be introduced in stages, so it's starting in November 1st. So anybody graduating at the end of the semester will be under the new requirements for the postgraduate work permits. The language requirements will be a requirement for the program for the end of the year, and then the areas of study piece and the occupation or industry piece will be phased in for those who are entering Canada with study permits now. So it's going to be a phased approach. Open spousal work permits are changing for study permits and low-wage work permit holders. So previously, a spouse of any individual in Canada could get a open work permit. Those are now being limited to master's students or higher, and the program has to be at least 16 months in length. And although not quite officially announced yet, there will only be open spousal work permits for work permit holders who have closed work permits. They'll only be issuing those for when the spouse has a closed work permit for an occupation that is either a managerial level or a managerial level or a professional level. The next topic is flagpole appointments. So there has been a significant backlog in the processing of extension applications right now, and that creates a whole host of problems for individuals who are here on work permits. And one of the solutions for that, for those who do not require a visa to enter Canada, is to go drive down to the border, circle, cross into the United States, circle around, come back in through immigration and get their work permit process. So there's been a lot of that happening lately, to the point that the borders have been putting in new rules in order to help manage the volume of cases. So in Ontario and BC, there are specific windows of time in which you can go and do that. If you don't present yourself during the specific windows of time, they will not decline to process your request. And this can provide further complications if you may or may not still have ability to work once you've exited and re-entered Canada. In Quebec, they've taken it a step further. You have to book an appointment. If the queue is long and you don't get to process your application within the period of time, they will tell you to come back. We've heard a lot of cases of people being told to leave and come back at a different time. So there's been a lot of confusion on these flagpole procedures. And again, each province is dealing with it differently, even though Border Services is a federal agency. During COVID, because you weren't able to travel, it was possible if you were a visitor in Canada to apply for a work permit through an inland process. It was a very specific allowance for that period of time. They canceled that in August of this year. So you can no longer apply for an initial work permit as when you are a visitor in Canada without exiting and re-entering Canada at the very least. About 2 weeks ago, there were some very significant changes to the intercompany transferee program, which is a work permit program allowing employees to transfer within their company from outside of Canada to inside of Canada. The changes were not necessarily new, but they refocused some of the criteria and raised their level of importance within the program so that the operational structure of the program is much more restricted. There are bigger concerns about having to meet prevailing wages. There are, companies now have to meet a criteria of actively doing business in Canada, which means they need to be generating revenue and they need to be providing a service or product. If you're a new entrant into Canada, then it's a slightly different program in which you need to prove that the company has the capacity and the intention to actually set up business within Canada, and you get limited work permits on that. So they completely, again, the details themselves are not new, but they've completely restructured the program. And again, it's a very new update, and so we're still understanding how these pieces come together, and there's been a lot of debate within the bar about whether IRCC can even, in good faith, put some of these things forward. Some of this tightening up is also, we'll say, bleeding into the intercompany transferee programs under the free trade agreements, which is also something that's being put in question as well, because there are different international obligations under those treaties. Okay, time for a breath, and we'll flip to the next slide. Tim, did you have something you wanted to add?
Yeah, thanks, Sarah. There's a lot, again, when we have Sarah on these webinars, there's a lot to unpack around immigration. Sarah, are you going to continue with this slide in terms of immigration, or shall we go back to freedom of expression in Quebec?
If I can finish this slide, and let's go back to freedom and expression, and if we get time for the case I was going to talk about, then
Perfect.
We'll do that later. Yeah. Okay, great. So for bridging, this slide is more focused on permanent residence and provincial nominee programs. So bridging open work permits for those awaiting PNP application processing. For those who are in an expression of interest queue or are waiting on a decision on a PNP certificate, there is a new provision that allows the individual to get a letter from the province under which they're applying in order to get a work permit to extend their stay in Canada while that application is being processed. You could always get the new work permit once you got the certificate, but now there's some allowance, some understanding that processing is taking much longer than anticipated, and you can get those letters to extend your work permit if you're still in the assessment process. In Alberta has completely restructured its P&P program under moving to an expression of interest platform where candidates are then ranked and issued invitations to apply. That came into effect on the 30th of September. Quebec, there are lots of changes coming to the Quebec Permanent Residence Program, and there'll be more coming before the end of the year. But the one to note at the moment is that they are putting caps based on country of citizenship for the Quebec permanent residents. So the rule is no one country can exceed 25% of the invitations to apply for Quebec permanent residents. Right now, the example for that has been Cameroonian citizens. Apparently, there's been a huge number of Cameroonian citizens in the program. So that will be exclusion based on citizenship. It's going to be interesting to see how that actually plays out and if anybody actually challenges that position. And then the last item is employer registrations, provincial registrations. So there's been an increasing trend across the country where the province is requiring any employer who employs foreign workers to register with the province as an employer of a foreign worker and provide certain data in order to access certain programs. And it's very different from province to province. So New Brunswick's program, if you have any foreign workers, you need to register. Nova Scotia has a very vigorous program. British Columbia has a significant program where in order to apply for a labor market impact assessment, you do need to do the registration. It takes about 7 weeks to get an approval. So, and applications will not be processed unless those registrations are done. So that's been introduced very, very quietly, but it is becoming something of a challenge. Just checking because you go. There are also changes to the high wage and low wage LMIA programs. The changes to the high wage programs were announced last week. The one piece regarding who qualifies for a high wage program is effective on Monday, October 28th. So in order to qualify for the high wage program, previously you needed to be above the median provincial wage. That has now been increased to the median provincial wage plus 20%. So we're going to see a significant band of people no longer eligible for the LMIA program in which they originally applied when they come up for renewal. The second change to that program is to, as of November 8th, attestations will no longer be accepted. So for when you're making an LMIA application, you have to provide business legitimacy documents. When you provide those documents, one of the documents you could provide was an attestation from a registered lawyer or accountant saying the company has finances to cover the cost of the employee and is legitimately doing business in the province. Those are no longer being accepted, and they are now going to rely on cross-ministry information verification. So you'll need to sign off on the LMIA that you consent to the exchange of information, and they'll be confirming the business status directly with entities like the CRA and some of the more business-focused ministries. Changes to the low-wage program were announced at the end of August and are now put in place for the end of September. So if you are applying for a low wage program, if you are making an application in an area where the unemployment is over 6%, and then they will not process your application. They will decline to process your application. You will not be able to get a low wage LMIA. That change is effective both within the federal program and within the Quebec Simplified Process program. They're also putting new caps in place, so you cannot get low wage LMIAs if more than 10% of your workforce is a foreign worker on an LMIA, with the exception of food manufacturing, construction, and healthcare, where the cap is 20%. They'll no longer be 2-year work permits. They will be 1-year work permits, which means you'll need to renew annually, which will probably mean being perpetually within this immigration system the way it's currently structured. One good piece of news is that the primary agricultural program is exempted from any of these rules, so it is not touched. So if you're in a primary agriculture business, it's business as usual. And those are the hot topics in immigration at the moment.
Okay, thanks, Sarah. That's a lot. Again, I know I repeat this every time you speak about immigration, but that's a lot to process because there's so much going on, so many pieces at play. So appreciate you filling us in on at a very high level. Let's go back up to the Quebec freedom of expression, back to Caroline Bernier, and then we'll then get to some case law updates.
Absolutely. Thanks, Tim. We can go to the next slide. Essentially, we wanted to bring to your attention the recent decision by the Administrative Labor Tribunal, that is CSN against Amazon, and it's essentially because the decision is of big importance in Quebec because it marks an important departure from years of jurisprudence related to the employer's freedom of expression in the context of union drives. So if I do it very, very shortly, in June 2023, the union filed a complaint against the employer Amazon pursuant to the Quebec Labor Code, alleging obstruction attempts to prevent employees from joining the unionization movement underway. And Amazon asserted that it had not excessively exercised its right to freedom of expression or obstruction of the union's action. That had been the second unionization attempt by the union. And following the beginning of the drive, Amazon was quick to respond and issued a series of coordinated messages in connection with ongoing with the campaign. It continuously broadcasted its messages on the screen and included factual information, and also inserted information on table toppers in the cafeteria, in the break room, and even on bulletin boards in the washrooms. And what's interesting is that what Amazon did is essentially what most employers in Quebec would do, because this had been accepted practices for a big number of years. And the messages that Amazon was vehiculating, was communicating, were pretty objective and factual. So they said a union card is a legal document. Unions can guarantee changes in the workplace. You don't have to provide your personal information. Joining a union is a personal choice. It should not be taken lightly, and you have the right to decide whether or not to sign a card. So they were pretty mellow messages, but the tribunal assessed the overall facts of the case in light of the applicable case law, and determined that there's two important factors that had to be taken into consideration to determine if the complaint was founded. And the first one was the vulnerability of the union, considering that it was at that time in the process of formation, and that it had been the second attempt to organize Amazon employees. And the second one, which is interesting, is the worker profile. So it noted the fact that there was a very high proportion of immigrants that probably lacked information about the legal framework governing labor relations in Quebec, and so put them in a very vulnerable position. And the tribunal found that through the messaging that Amazon had been sending out, it was not appealing to people's logic, but it was really trying to elicit an emotional response. Employees didn't really have a choice to receive the message in question since it was pretty much present everywhere, even in the washrooms. And Amazon was using its authority to propagate its anti-union views since it had coached its supervisors in how to properly answer in objective ways, but still how to properly answer to questions. And so the tribunal upheld the obstruction complaint and ordered Amazon to pay the union a total of $30,000, $10,000 in moral damages, and $20,000 in punitive damages. Amazon filed an application for judicial review with the Superior Court of Quebec, and that may provide a bit of comfort to employers because otherwise it would pretty much change the landscape of how an employer can respond to a union drive in Quebec.
And Caroline, that case will be heard at some point and a decision rendered on appeal.
Yes, exactly.
Yeah.
Well, in judicial review, it's not an appeal, it's a judicial review. So the criteria are harder to meet, but yes.
Yeah. Well, that's a very interesting case because, the way I read this case, it's not about the fact that Amazon was saying things that were improper. It was almost the repetition of it, the in your face. It was everywhere, and putting messages in the washroom. I mean, I don't know. Maybe I'm a little jaded on that, but I would have thought maybe there's certain areas that you don't, send messages to employees about staying union free, and a washroom may be one of those. But we'll see what the judicial review says about that. But a very interesting case because that does have implications right across the country in terms of freedom of expression of employers, which is contained in most labor relations statutes. So thanks for bringing that case to our attention. So let's go down to the section 4 where we get into family status discrimination, workplace harassment cases, because I think in the interest of time we want to make sure we cover that. So I'm going to turn it over to Marco, who's going to lead us off with an Ontario case or two.
Great. Thanks, Tim. And so the first case here on your screen, Cosentino versus Octapharma Canada. This is really a case that highlights the ongoing nature of the duty to accommodate. So we'll just spend a few quick moments on this. So here the employer had already agreed to flexible working hours for the applicant so that she could care for her mother who was diagnosed with a medical condition that had required treatment. And this all takes place in mid to late 2020, so peak pandemic. Months later, and while the initial accommodation was still in place, the applicant's mother injured herself, which necessitated additional care. And this additional care led to a second request for further accommodation, including work from home arrangement requests, again, late in 2020, peak pandemic. The employer declined the subsequent request, believing that the current flexibility provided was sufficient. In essence, they expected that the applicant would attend the office for the remainder of a workday after any medical appointments that she had to attend with her mother, who required some care. And all the while this had all happened, the employer had raised a few performance concerns regarding the applicant's performance. They were placed on a performance improvement plan and noted some concerns regarding their performance in their working relationship. The applicant proceeded to commence this claim, and prior to that, actually, the employee's employment actually was terminated without cause at the end of 2020. The applicant proceeded to commence this claim with the tribunal, and the tribunal ultimately held that the applicant's situation constituted discrimination and that the employer had reprised against them. The tribunal here criticized the employer for not exploring alternative accommodations beyond flexible working hours and looked at the lack of comprehensive engagement in the accommodation process as a failure in the employer's duty to inquire fully about potential accommodation. The tribunal also found that the applicant had met the test for reprisal, as the working relationship had deteriorated significantly after these accommodation requests had come forward. They were denied vacation time, excluded from certain presentations that they'd previously been a part of their role. They refused to cover registration fees for a virtual conference that the applicant had regularly attended, and so on. And then you'll see here that it's on the screen, the tribunal ultimately awarded a pretty material award, and in particular $25,000 as damages for injury to dignity, feelings, and self-respect, which is quite high for our Ontario tribunal. And so this highlights the ongoing duty of the ongoing nature of the duty to accommodate. And just because an initial accommodation is sufficient doesn't mean that the nature of that accommodation might not change, and that might necessitate further discussion and dialogue between employer and employee. Just quickly on the second case, so this is the Agwell versus Family Options Inc. case. And so here the applicant had worked as a residential support worker. They didn't wish to work certain shifts because they were a single parent with a young child at the time. And she alleged that her employer had refused her request to alternate working different Sundays, and claimed that the employer not only denied her request, but also had reduced her shifts in retaliation. The tribunal actually here disagreed, and it declined to find that the applicant had actually been discriminated against on the basis of family status. The tribunal concluded that some of the emails, and this is where evidence becomes particularly important in the context of these human rights cases, in their emails to the employer, the applicant didn't actually specify that their shift change as an accommodation request or mention childcare concerns. So for instance, she had testified that she could work from 4 p.m. to 12 a.m., although the shift extended to midnight and was not ideal, and it made her unhappy. And so in looking at this, it's just a reminder that employees are not entitled to perfect or ideal accommodations, and an employee's individual accommodation needs must still be practical within the employer's operations. Here, as a residential support worker, they were on, it was restricted shift schedules. There was limits on the amount of staff able to cover certain shifts, and the resources were ultimately limited. And the tribunal considered all of that in finding for the employer in defense of this application. And so with that, I know that my colleague Kim has some further updates for Ontario, and so we can just move over to the next slide.
Hi, Kim, would you like to tell us about the Metrolinx case? Oh, we're having a hard time. I'm having a hard time hearing you, Kim. Okay, it still doesn't seem to be working. So why don't we do this? Why don't we'll go back to Kim. Why don't we go to the next slide, and we will let's go to Alberta, and Justin, maybe you can give us a sense of what's happening in the world of discrimination and workplace harassment in Alberta.
Great. So we have 3 cases from Alberta to bring to your attention. So the first one has to do with some pretty significant general damage awards in Alberta. In addition to these general damage awards, there are also awards for lost wages in this case. These are 3 individuals who ended up quitting or not returning from a mat leave due to the discrimination they faced in the workplace. And so the discrimination was largely sexual harassment, and just to give you a flavor of what they were facing, nicknames: baby girl, baby, Mrs., the owner's name, sugar baby, sweetheart, sexy, hun, sexy mama. They were being told to wear something sexy for client meetings. The owner would say that they were overdressed. The owner would make negative comments about his wife and saying he was looking for someone younger to have kids with. He would try to hug them, kiss their neck, kiss their cheek, invade their personal space. Overall, very touchy in the workplace, touching their shoulders, slapping their backsides, gifting teddy bears, saying "I love you," suggesting they grab some wine and sit on a rug in front of a fire, criticizing job performance in the sense of criticizing them for not wanting to go for lunch alone with them. Surprise, surprise. And then even more egregiously, one was pregnant or got pregnant and disclosed that to the owner, and the owner made a comment that she was no longer good for the position of executive assistant. And he did also offer money for sex and a baby. So some fairly significant sexual harassment. There was also discrimination on physical disability. And there it's a little bit more interesting and maybe more of a takeaway in the sense of asking for too much medical information. The individual wanted to take the morning off for a doctor's appointment. The owner, under the guise of, we're all family here, wanted to understand what the nature of the doctor's appointment was and really pushed for her diagnosis, which was improper, which also warranted some general damages. And then retaliation was in the sense of the owner did commence civil claims against 2 of the individuals, and the tribunal found that that was improper to do and was retaliatory in nature. So this is a high watermark for general damages in Alberta. It's also indicative of a trend overall of what we're seeing for general damages being higher and higher, I think really across all provinces, and this is something to watch. So maybe moving on to the next slide. So we have two cases. The first one's fairly straightforward. It's a little bit of a good reminder. It is that simply that this had to do with the flu. Common physical ailments like the flu do not constitute a physical disability if they are lasting for a few days. So that is something to keep in mind. Something that's maybe also to keep in mind is that oftentimes employment standards legislation will provide for job protected leaves for those types of short-term illnesses, and so that's important to remember. So although there might not be some human rights obligations in terms of a duty to accommodate, there can be and often is some other employment standards or other job protected leaves that you need to consider. The last case is also interesting. This is, I think, something we're seeing over the last 5-7 years of less and less tolerance, I think, in society, but certainly from adjudicators in terms of racial slurs or sexual harassment. And so this was the griever made a complaint because they had an altercation with a coworker. The company conducts a workplace investigation. During the workplace investigation, they discovered that the complainant, the griever, made a statement of "I'm not your N-word" during the altercation. So the complainant becomes a respondent as well. And really 3 takeaways in this case, really. First takeaway is it's really important when you're doing a workplace investigation to constantly assess whether or not the allegations or issues are changing. And sometimes you might have a situation like this one where a complainant will also turn into a respondent. And the other 2 takeaways are really this idea that termination or at least a lengthy suspension is the appropriate remedy for when a significant racial slur like this is stated in the workplace. And thirdly, what was also interesting was that there was a very firm rejection of this defense or notion that a person of color or anyone born in Africa has some sort of special dispensation to use the word or the N-word. And so that is not really a mitigating factor. Certain people of color cannot use the N-word, and that would not be an appropriate defense for workplace conduct. So those are the 3 takeaways from that case. I think it's a helpful case for employers when they're dealing with these types of issues. And then I think we're going to BC.
Yeah, and before we do that, Justin, I think I just want to go back up to Kim Lennon in Ontario. I think she's got her audio issues resolved. We can, yeah, great. Kim.
Okay, awesome, thank you. Sorry about that. So this is the decision of Metrolinx and the Amalgamated Transit Union Local 1587, which is a recent decision out of the Divisional Court. So this was an application for judicial review following a decision in which an arbitrator had ordered the reinstatement of 5 GO Transit employees that had been terminated from their employment for cause. So the Divisional Court found that the arbitrator's decision of this reinstatement was actually unreasonable and granted the application. So by way of background, these 5 GO Transit employees, which I will refer to collectively as the grievers, were part of a WhatsApp group on their personal cell phones. And while investigating a completely unrelated matter, the employer's HR department was informed by an employee that this WhatsApp conversation between these grievers and other employees in the workplace contained a series of negative, derogatory, and really sexist comments about another female coworker. So once the HR team became aware of this, they reported these allegations to the Employers Harassment, Discrimination, Prevention Department for investigation, and an investigation commenced shortly thereafter. The investigator interviewed all of the grievers and a series of other witnesses and relied upon screenshots of this WhatsApp conversation that were provided to them by one of the grievers. So ultimately, the investigation was substantiated, these allegations were substantiated, and Metrolinx decided to terminate these 5 grievers for cause. The arbitrator found that, or conceded that these texts were really shameful, but noted that they mainly occurred outside of the workplace on the grievers' own time using their own personal cell phones through an online medium they reasonably believe intended to be private. So he ultimately reinstated, I know we're running out of time, so I'll try to zoom through this, but he ultimately reinstated these grievers on this notion of privacy, and the employer, of course, sought judicial review. So at the court level, the divisional court held that an employer's statutory duty to prevent harassment under both the Human Rights Code and the Occupational Health and Safety Act remains in place whether or not an individual complainant comes forward or not, because in this instant, the female employee whose messages these were about was not actually complaining, didn't participate in this investigation. The divisional court also recognized that in instance of harassment, specifically sexual harassment, it is common for complainants to be afraid to come forward, and therefore the presence or absence of an individual complainant is not what triggers an employee's duties under the OSHA. So a few key takeaways here. An employer's obligation to prevent workplace harassment remains in place regardless of whether a complaint is formally submitted. Even if conduct occurs outside of the workplace, it will not automatically bar an employer from disciplining workers if that conduct makes its way into the workplace. And privacy concerns, while important and should definitely be evaluated on a case-by-case basis, do not automatically bar an employer from commencing an investigation into issues affecting the workplace. So that's it for me. Thanks, Tim.
Thanks, Kim. That's a really interesting. It's quite long, but there's a lot to unpack there because it deals with a whole bunch of issues regarding investigations, workplace harassment outside the workplace on an app amongst employees, private site. It's an interesting case, and you see how the law has developed. Some ways beneficially, in other ways not for employers. We're getting close to the top of the hour, but I did want to just get to British Columbia. Sarah, and maybe you can just take a quick stroll through the 3 cases there, and I'm not going to be able to deal with. We have a lot of questions. I've tried to intersperse them within the presentation. I can tell you, folks, that the gig worker statutory changes at the start of the presentation have created a firestorm of questions. So we'll try and deal with those after the webinar is open. But turn over to Sarah quickly. Stroll through the cases for us in BC around discrimination and workplace harassment.
Thanks, Tim. And I'll keep it really high level in the interest of time. But one of the most significant cases to come out of BC in the past year, and kind of goes with the case that Justin talked about earlier, is that this year, the BC Human Rights Tribunal in Mrs. L versus Clear Pacific Holdings Limited issued the second highest award in the province for damage to injury to dignity, hurt feelings, and self-respect of $100,000. But this was also the highest award ever for sexual harassment. So the complaint was awarded $100,000 in injury to dignity damages, but also $61,000 in lost wages and $8,700 for her expenses. Just broadly speaking, it's a long case with a lot of facts, but it's quite unusual as the complainant was in quite an abusive relationship with her employer. So she was sexually harassed and assaulted by her employer, and her employer also took advantage of her substance addiction by giving her drugs. So the complainant alleged that she had been discriminated against by her employer on the basis of her sex and disability, which was her substance addiction, in violation of Section 13. And the tribunal found that complaint to be founded. Interestingly, in this case as well, the complainant also had a separate WorkSafe claim because her employer physically assaulted her, so she received WorkSafe benefits as well. So obviously, kind of the worst of the worst cases factually, but this case does represent an increase in awards from the BC Human Rights Tribunal, a trend in increasing awards for sexual harassment. So that's the first case. The second case, Scherer versus Mount Baldy Resort Inc. and another. So in this case, this was an application to dismiss decision. The tribunal denied the application to dismiss the complaint, and it will proceed to a hearing. So in this case, The complainant alleged that her employer, Mount Baldy Resorts, had discriminated against her on the basis of sex in her wages, so contrary to Section 12 of the BC Human Rights Code. The basic facts of the complaint were that the complainant was a manager at Mount Baldy Resorts, and she alleged that she was paid less than her male counterparts for doing the same role with the same duties and the same experience. And so the employer argued that her predecessors in the role, who were men who were paid more than her, had more experience, and that she was also paid less because of the company's financial position. But the tribunal did not accept these arguments to dismiss the complaint, and it will proceed to a hearing, finding that the employer had not provided enough evidence. And I think this case is really important, especially with the pay transparency legislation that's come out recently. So with this new pay transparency legislation, employees are going to become more aware of when their colleagues are potentially making more than them, and we may see more complaints like this in the future. And then just really briefly, this last case, Fife versus UBC, was also an application to dismiss decision. The complainant was a former employee of UBC whose employment with UBC was terminated, and alleged that her employer had discriminated against her contrary to Section 13 based on her race and color. She claimed her termination was influenced by subconscious discriminatory attitudes about Black workers. So in this application to dismiss decision, the interesting part was that the employee had actually accepted a severance package from the employee and signed a release, which released all claims under the BC Human Rights Code. However, the complainant argued in this application that she had been under financial pressure to sign the release because she had to pay her rent and she didn't really understand the release. So although she had signed a release, the tribunal considered if the complaint should proceed, and it found that it did. And the tribunal reminded us in this decision that even if an employee signs a release, it's not necessarily a bar for the employee from a complaint from proceeding, as the Human Rights Code specifies that the parties to a human rights complaint cannot contract out of their obligations under the Human Rights Code. And so because of conflicts in the evidence about what happened at the termination meeting, the tribunal could not dismiss the complaint, and so it will proceed to a hearing. So as mentioned, this case is just a reminder that even if there is a release signed, that doesn't mean that a human rights complaint will not proceed. It's not a complete bar to a complaint proceeding. So those are my high-level points about those three cases.
Thank you, Sarah. I appreciate that, and thanks for squeezing it in. Well, that concludes our presentation today. Thank you, experts. I'll use the word brilliant again. That was brilliant. I really enjoyed that myself. I'm hoping the audience did as well. We didn't get to all the questions that were asked. We will attempt to do that afterwards and follow up some of the questions. As I said, actually many of the questions related to the gig issue, which is very topical. So we'll look into that and get back to you. Anyway, appreciate all of you tuning in today. This concludes our webinar series with MONDAC this year. We will see you again next year and look for updates from us both on the MONDAC website in terms of our annual updates and our blogs, as well as information about our next legal update. So thank you, panelists. Thank you, audience. Thank you, MONDAC. Have a great day.